Well, good morning, everyone, and thank you for joining us. This is our virtual town hall for the Summerville Bypass Project. My name is Michael Gault, and along with Lindsay Carrington, we are eminent domain attorneys with Bell, Carrington, Price, and Gregg. As part of our practice, we seek to help landowners in eminent domain matters on road projects like this throughout the Carolinas, Georgia, Alabama, and Tennessee. But obviously, if you're here today, then you're here to learn more about the Summerville Southwest Bypass Project. And so, our goal in this virtual town hall is to sort of give you some general information about the project itself, and then to dive a little bit deeper into some generalities around eminent domain matters and condemnation matters. Uh, we're not here to give legal advice, unfortunately, in this sort of a public forum. We're not able to do that. But later on in the stream, you'll see our contact information pop up, an email address and a phone number to where you can reach out to me. You can reach out to our team, and we're happy to connect with you to have a more one-on-one conversation to where we may be able to enter into that attorney-client relationship and certainly provide some legal advice. We'll get more into that and how that consultation works as we get toward the end of the stream. But let's just jump right into the project. If you live, work, or are in or around this area, then you've likely been hearing about this project for some time. It's been in design for a number of years. The project has been ongoing for a number of years, and now we're down to the time to where right-of-way acquisition is beginning. What does that mean? Essentially, this project is a new roadway. So we are starting, if you're familiar with the area, which most of you are, we're starting over set on the south side of Summerville at the Sugar River crossing, and that's where the project on the south side of Summerville, crossing over Town Branch with a completely new roadway to bypass SR1. As part of this project, there are going to be 3 new roundabouts constructed, a number of intersection improvements that go on. And so this project is, a major project. It's something that's going to impact lots of landowners because of the new construction. In order to complete this project, as you can imagine, the DOT will need to obtain private property. They're going to need to either purchase or take private property. When they take private property for a public purpose, that is what is known as eminent domain, and that's a power that the government has and a right that the government has in the United States. Now, just because the government has the right to take private property for a public purpose does not mean that those landowners that are impacted, many of you, don't have rights. You do. And among the most important of those rights is what we call the right to just compensation. And in a nutshell, that means that even though the government has a right to take your property for this public purpose, they have to fairly and adequately compensate you for what the property is worth, for what they're taking from you. Now, that's not always as simple as the dirt value. That's not always as simple as saying, okay, this property is worth X amount of dollars per acre. Oftentimes, many of you are business owners or you have homes on the property. You might have had plans for the property. Any number of things that we call damages may result from these takings that may not be offered to you by the DOT when they come around with their initial offer. It's important for you to know that you don't have to accept that initial offer. Oftentimes, the people that present those offers to you will be well-versed and well-experienced in eminent domain matters. They do this for a living, and I highly doubt that many of you do. In fact, I would say that most of you have never had to deal with something like this before in your lives. And so for that reason, that initial contact, that initial offer, the experience is on the other side for you. It may be a little bit overwhelming. It could be a little bit scary. And we certainly don't want you as landowners to be quickly into accepting some offer that does not really fairly and adequately compensate you for what you're owed. And so that's where we come in. We like to help landowners through matters like this by reviewing the offers, by reviewing the impacts, by making sure that nothing is left off the table. You only really have one bite at the apple when it comes to recovering damages or just compensation for these impacts. You can look at plan sheets all day long, but if you don't know what you're looking at, then it's hard to really tell what the project is going to look like once it's completed. And so let's say, for example, the DOT comes to you as a landowner in the next few months, and they make you an offer and you accept it. And a couple of years go by and construction is finally complete. And once they complete the roadway through your front yard, you see that it's nothing at all what you thought it would be. It doesn't look anything like what you thought it would look like, and the damages are far more severe. And at that time, you try to go back and say, "Hold on, wait a minute. This is not what we agreed upon. The damages are far more. I think I'm owed more money." It's too late at that point. You have to capture this just compensation and these damages on the front end, and you have to be careful about how you proceed through these cases to make sure that your rights are protected. Again, one bite of the apple when that happens at the beginning. Quickly, the eminent domain process sort of works like this. At the outset, there will be contact from the DOT or a third-party right-of-way agent. They're going to reach out to you and tell you if you're impacted and how they think you're impacted and what they're prepared to offer you for your impact. And there'll be a time for negotiation. If that fails, if that negotiation is unsuccessful, then eventually there's a court filing known as a condemnation. And that's essentially the lawsuit filed by the government that gives them the right to take your property. And the negotiations continue through that lawsuit. It doesn't end the negotiation at all. It just happens in a different medium. And there are a number of things that have to happen through the condemnation process, mediations and depositions. And ultimately, if the negotiations are unsuccessful through the condemnation process, then you as a landowner have a right to a jury trial for a jury of your peers to look at the impact to your property, and they'll tell you what they think it's worth. Now, realistically, very few cases go to trial. That's just the nature across most subject areas in the law right now, but even more so in eminent domain matters. But it could come to that, and you just have to know that is one of your rights as a landowner in an eminent domain case. We'll finish up quickly here. A couple of things that I want to sort of assure you of about our practice at Bell Carrington in eminent domain matters. The first is that our initial consultations are always free and no obligation. We invite you to reach out to us. We do this every day, and so we want to talk to you as landowners to find out if you're impacted. Like I mentioned, you'll see in the description or in the chat box a phone number and email address to contact our team. We are fortunate at Bell Carrington to have some in-house software that will allow me to pull up the impact to your property in real time while we're on the phone during that initial consultation. I can quickly and clearly see how you're impacted based on DOT plans and our GIS software so that we can have an honest and open and intelligent conversation during that first consultation about the potential impact to your property and how we may be able to help. And the second thing is concerning attorney's fees. Oftentimes folks are hesitant to hire a lawyer because of presumed high attorney's fees, expensive attorney's fees and retainer agreements. At Bell Carrington, in our eminent domain practice, and this is pretty typical, but we charge what's known as a contingency fee. So we're not looking for upfront or out-of-pocket retainer fees. In fact, there'll never be an upfront or out-of-pocket fee owed from a client in an eminent domain matter. Instead, we operate on a percentage of what we're able to recover for you through just compensation with the DOT. It's hard for me to dive into the specifics of that fee agreement or that fee arrangement in a public forum, just because each property is a little bit different and those fees can vary depending on the type of property. But if you'll reach out to us, we're happy to dive deeper into what that contingency fee structure looks like. But it is important for you to know that you'll never have to come out of pocket for any upfront retainer or attorney's fees or hourly billing, anything like that throughout the pendency of the case. The fee is just simply a percentage of what we're able to recover for you at the end of the day, be that through settlement or through a jury verdict. And if we're not successful in recovering for you, then there's never any fee owed. So just to recap, the project, major project, new construction, lots of impacts. There's between a $12 and $13 million right-of-way acquisition budget for the property that the DOT will need to acquire as a result of this project. South side bypass, southwest side bypass, down below Summerville. And if you're watching this, there's a good chance that you are impacted. And so I invite you to reach out to me. You'll see an email and a phone number. We're happy to speak with you. Our team is standing by. And I hope that we were able to provide some decent information for you about the eminent domain process and this project this morning. Again, Michael Gault, Lindsay Carrington, Bell Carrington, Eminent Domain Practice Group, and I want to thank you again for joining us. And thank you and have a good day.